than Congress's, because here CCE gave defendant 7 additional months of imprisonment. So the approach that North Carolina has taken to criminalizing and prosecuting.
Now, when you say it gave him 7 additional months, that's because the sentences were concurrent. Right?
That's right.
If they had been consecutive, it would have been how much more?
That's certainly true, but
a lot more.
In terms of the severity of the punishment that the General Assembly has chosen to impose, it's pretty comparative to trafficking. So it's, in that way, it's much different than the approach that Congress has taken when it enacted the CCE statute. So again, you know, the General Assembly.
So I guess, and the other thing, like I mentioned before, that seems odd to me. So if this was enacted, as you've said, you know, to obviously impose additional punishment on the people who are the kingpin, I'll say. You know, it focuses on that. You've got this at least 3-level organization. You've got, you know, with the top and then the middle people and then the people at the bottom of the enterprise, so to speak. But with aiding and abetting, why would the aiding and abetting theory here not apply to every single solitary person in that entire pyramid, we'll say, which would impose the exact same enhanced punishment on every single person in that entire pyramid?
Well, one thing I would note is that to prosecute an aiding and abetting charge, it's not enough that the state necessarily just show mere involvement. There are specific elements that have to be met for aiding and abetting. You know, Judge Murphy was asking about, you know, a secretary who doesn't care at all about drugs. You know, that I don't think would meet the elements of an aiding and abetting charge. An aider and abetter, the jury must conclude that the defendant knowingly advised, instigated, encouraged, procured, or aided the other person, and that the defendant's actions or statements caused or contributed to the commission of the crime by the other person. So
if the secretary sets up, you know, a meeting with someone, would that not be, you know, she knows they're going to sell drugs. She knows what the purpose of this meeting is because she knows the organization she's working for, and she sets up the meeting for this transaction to occur.
Right, so one could imagine facts where somebody occupying that role could meet the elements of aider and abetter, but you could say the same thing for an aider and abetter of drug trafficking, or the same thing for an aider and abetter of murder, or the same thing of aiding and abetting another crime.
Well, yeah, but wouldn't it cover almost anyone involved in this pyramid? Anyone who's one of those 5 people or more in the middle would probably fall under that. And then everybody at the bottom who sold any drugs, bought any drugs.
Well, I think you're getting at a distinction that the court made in Pino Perez. Judge Posner said, look, this statute contemplated the participation of the individuals who were supervised by the kingpin. We don't think those people should be prosecuted for aiding and abetting, but if you're outside the organization, meaning that you're not directly supervised by the kingpin, aiding and abetting is fair game. Mm-hmm. So one of our arguments in our brief, I mean, I don't think the court needs to reach that distinction because here, defendant was clearly outside the organization. There's no evidence that he was directed, managed, supervised, or anything like that by Bullock or Tate. And just to get back to the point about the plain language of the statute, I think these examples that I've cited demonstrate that the General Assembly could have said and knew how to say that aiding and abetting constitutes a lesser crime. It could have said that aiding and abetting is not a crime at all. It did neither of those things. And in fact, it's the defendant that's stepping outside the statutory text by asking this court to draw an inference about the General Assembly's intent to abrogate the common law by appealing to those federal cases and by appealing to, it seems like what he's arguing is that a primary purpose of the statute is to punish drug kingpins. We don't dispute that. And to go back to Judge Murphy's question, you could say the same thing about a statute criminalizing homicide. You could say the same thing about a statute criminalizing rape.
But again, those crimes don't require an organization, right?
That's true. Yeah. And I think what I'd say in response to that is certainly a purpose of the General Assembly here was to punish drug kingpins. But it could also have been a purpose of the General Assembly to ensure that these types of broad criminal organizations that are engaged in these series of violations are prosecuted and associated with them. There's no reason to infer some purpose to abrogate aiding and abetting absent some clear indication from the General Assembly. And the mere fact that this crime aims at criminal organizations, I don't think is sufficient to conclude that the General Assembly clearly wanted to make prosecution for aiding and abetting unavailable to the state. And I think that's the test that this court has to use for determining whether to determine that the prosecution for aiding and abetting in this case was not available. So I'm happy to get into the federal case law on this if the court has any questions. We think that for purposes of construing whether the General Assembly specifically intended to abrogate common law, this court is on a much better footing if it's looking at the text of the statute, the circumstances around the statute, and North Carolina case law. And what the federal courts were looking at was congressional intent, congressional legislative history, which I don't think is sufficient to provide a clear statement of North Carolina's General Assembly's intent to abrogate the common law doctrine of aiding and abetting. So for those reasons, unless there are any further questions, we respectfully ask that defendant's convictions be upheld. Thank you.
All right. Thank you. And rebuttal?
I think I have plenty of time, but just 3 quick points. First, as to the state's argument that an indictment is generally sufficient if it tracks the statute, that might usually be the case, but there are times where there are elements that are not expressly laid out in the statute, and they do still have to be alleged in the indictment. For that proposition, I would point you to Rankin from our Supreme Court a couple years ago. I want to say 2018, but I'm not sure about that. The second point, this would be about your question, Judge Stroud. Allowing aiding and abetting liability, wouldn't that extend full kingpin liability to everyone who is a member of the organization? Yeah, that's part of the problem. And if the state is correct that Mr. Guffey, looking at the evidence in this case, Mr. Guffey was either a rather small part of Tate and Bullock's organization, or he was an outside buyer. If he was wholly an outside buyer like the state is now arguing, that means they're arguing that aiding and abetting liability should extend even to ordinary buyers, which is a pretty significant escalation when the statute is aimed at kingpins. And the third point, there was a question speculating about why the statute has been on the books for 50 years but hasn't really been used very much. I suspect it's because in the late 70s and early 80s they introduced the trafficking statutes, which allowed for easier convictions. Far fewer elements, just simpler charges to prove. So if there are no further questions, I would ask this court to vacate the trial court's judgments and remand for further proceedings.
Did you have anything else? I'm looking at your reply brief on the ambiguous verdict argument.
Yes.
Do you have anything else in response to, I think the state, it's referencing, sorry, here. To the right place. State's reference of Lorenzo and Rozier that stand for this act, that the single act of conspiring is inclusive of possession, transportation, or delivery?
You're looking at the line of cases stemming from McLam. I will admit I overlooked that holding and the line of cases the first time, but I do have some thoughts about it.
Okay, if you could.
McLam, as far as I can tell, it has not been overruled, and it would not even be fair to say that it has been overruled sub silentio. However, I do think it's out of sync with developments regarding unanimity since then. That's true for both federal law and for state law. If you look at cases like Richardson, Or if you look at the state level, the Hartness line of cases and the Diaz line of cases, they draw a distinction between elements, where the jury has to be unanimous, and different brute means or theories where the jury does not actually have to be unanimous. So if that's right, then McLam could only be right if the substantive object of the conspiracy is not actually an essential element of the offense. And I think that would be a difficult conclusion to reach, because we routinely instruct juries about the object of the conspiracy, and sentencing is normally linked to that. So I can't say that McLam has been overruled, but I do think it's out of sync with current developments on that, including some of the cases cited in the memorandum. I included Cox for the proposition that when, for a conspiracy, the conspirators have to agree about each element of the substantive object of the conspiracy, each element of the crime that they plan to commit. So if that's right, then it seems they would have to agree on what crime they actually mean to commit. And if that's right, then McLam is no longer really consistent with those, though again, I can't really fairly say that it's been overruled. I can say that there's at least some tension.
And until it's overruled, would you agree that in re civil penalty would tie our hands to follow the McLam line?
Since it hasn't been overruled, probably, but I would ask for a ruling on this.
Thank you.
So, if any further questions?
All right.
Okay.
Thank you very
Well,
much.
thank you very much.
And we'll take a break. And, yeah. Yeah. All right, and then we will proceed to our next case, which is State v. Cornwell. So y'all can just go ahead and switch places, or. Well, you don't really have to switch places, you know.